What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Friday, August 15th. Hope you guys have had a good day so far. Just want to give you a layout of how next week is going to go with Donna Adelson. Jury selection begins on Tuesday, August 19th. That is expected to take 2 or 3 days, and opening statements are tentatively scheduled for Friday, August 22nd. The state expects 6 or 7 days for their case, and the defense expects 4 to 6 days. It's a good reminder to subscribe to the YouTube channel if you haven't already. And if you want notifications of when I go live or post new content, click that little bell icon. We're going to go through Wendi Adelson's motion to quash that subpoena by the defense to testify at Donna's trial. But first, I've had a lot of people ask me about Wendi's immunity. She has derivative use immunity. So what does that mean? It means prosecutors cannot use actual words from testimony against you, and they also can't use any evidence they discovered as a result of your testimony. That is the derivative part. Now, if the state can prove evidence against you obtained independently but not through testimony, you could still be prosecuted. Now, Wendi filed pretty much the same motion during Katie Magbanawaz's trial. And again, she's filed one for Donna's. This was filed August 13th, so just 2 days ago. The introduction. Non-party Wendi J. Adelson is the daughter of defendant Donna Adelson and is expected to be one of the first witnesses called by the state in Donna's trial. Both the state and the defendant issued trial subpoenas to Wendi Adelson. By law, the state subpoena confers immunity on Wendi, but the defendant's subpoena does not. Accordingly, Wendi respectfully moves for permission to place a statement on the record regarding the state of Florida's trial subpoena and to quash the trial subpoena issued by Donna Adelson. In support of this motion, Wendi Adelson states as follows. Donna Adelson is charged by indictment with first-degree murder, alleging she participated in a conspiracy to murder Dan Markell, Wendi Adelson's ex-husband, on July 18, 2014. Other alleged members of the conspiracy were charged and convicted, including Katie Magbanawaz. In Katie's trial, both the state and the defendant subpoenaed Wendi to testify. In response, Wendi filed a motion, like the instant motion, to place a statement on the record and to quash the defense subpoena on May 13, 2022. Thus, the 2 trial subpoenas by each party in this case present the same issue the court dealt with in a previous trial. The state subpoena affords Wendi use and derivative use immunity for her testimony in an instance where she would otherwise invoke her Fifth Amendment rights, while the defense subpoena provides no such protections. In Katie's trial, the court quashed the defense subpoena and granted Wendi's attorney an opportunity to place a statement on the record. They have attached a transcript of that, and they ask that the court grant the same relief in this case. In the footnotes, it says, in the related hearing before the court in Katie's trial, Katie's counsel argued it would be a reversible error for Katie's cross-examination to be limited because the state can tailor their direct examination to prohibit Katie from going into areas that could potentially be relevant based on the deposition of Wendi. In that opinion, the first DCA did acknowledge that Katie would be given little latitude in her cross-examination of Wendi because her questions would be limited to the narrow categories of information the state elicits at trial. However, the first DCA did not grant Katie's requested relief in that appeal and recognized when the Fifth Amendment guarantee collides with the Sixth Amendment in circumstances such as these, the Sixth Amendment must yield because to require one to incriminate himself in order to afford help to another would be both unwise and unrealistic. And just this past month, the first DCA again addressed those same arguments by Katie. The first DCA found no error in the court's handling of Wendi's trial testimony, favorably cited Wendi's counsel's statement on the record, and concluded the trial court properly ruled she could not be called as a defense witness. Therefore, there is no reason to depart from the procedure employed by the court in Katie's trial. In Katie's trial, the court scheduled a hearing related to this requested relief just prior to Wendi's testimony. Wendi respectfully requests the court set a similar hearing on this motion outside the presence of the jury prior to her testimony or at such time deemed appropriate by the court. The next section is the Memorandum of Law. Part A. The court should allow Wendi's attorney to place a statement on the record regarding the state subpoena. Wendi will testify pursuant to the state subpoena, but without such a subpoena, she would invoke her rights under the Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Florida Constitution. As a result, Wendi requests that once the state calls her as a witness, her counsel should be allowed to place on the record a statement outside the presence of the jury that 1. Wendi intends to invoke her Fifth Amendment and Section 9 rights. 2. Wendi's testimony is entitled to use and derivative use immunity pursuant to Florida statutes. And 3. Use and derivative use immunity extends to any testimony given during Donna's cross-examination of Wendi. Given the state's theory of the case, there is no question that Wendi has a real and substantial interest in asserting her rights against compelled testimony. In these proceedings, Wendi has made a complete invocation of her rights under the U.S. and Florida constitutions. To ensure full protection of Wendi's rights, she respectfully requests the opportunity to state on the record her entitlement to these important constitutional and statutory rights. Part B. The court should quash the defense subpoena. Although Donna will have a full and fair opportunity to cross-examine Wendi at trial, and despite knowing that she would otherwise assert her Fifth Amendment rights, Donna's counsel issued the defense subpoena. Unlike the state subpoena, the defense subpoena confers no such immunity. They cite a case called Jenny and say it's limited to cases where the state subpoenas a witness to testify before the state attorney, grand jury, or before a court having felony jurisdiction. It cannot be invoked by the defendant to immunize a witness. The law is well settled that the purpose of Florida statute is to aid the state. A defendant cannot immunize a witness in order to secure the witness's compulsory testimony. They cite Jones versus State. Simply put, the defense has no ability to confer immunity upon a witness under Florida statute, even when the witness is likely to provide exculpatory and reliable evidence. If called as a defense witness, Wendi would invoke her Fifth Amendment rights to every relevant defense question. Therefore, any testimony Wendi provides beyond the matters covered under the state subpoena would result in a potential waiver of her Fifth Amendment rights, which she does not intend to do. Florida law is equally clear it would be improper for a party to call a witness for that witness to invoke her rights before the jury. They cite Ashley versus State, where it says calling a witness to invoke Fifth Amendment protections in front of the jury creates a dramatic moment, causing irreparable damage and injury in the eyes of the jury. Thus, there is no proper purpose for the defense subpoena, and it should therefore be quashed to ensure the integrity of the trial process and to protect Wendi from unnecessary harassment and abuse. Under these circumstances, the defense subpoena should therefore be quashed. They also attached relevant pages from Katie's trial transcripts that were related to the same matter. And from that transcript, it says, Your Honor, as you know, Ms. Adelson has been subpoenaed by the state as well as the defense. She, without a state subpoena, would invoke her Fifth Amendment rights. We want to make that clear for the record. In light of Your Honor's prior rulings and direction, we wanted to put that on the record. However, with respect to the state subpoena, it automatically confers use and derivative use on her pursuant to Florida statute. That use and immunity would only apply to a state subpoena and not to a defense subpoena. So in light of that, we would ask respectfully the court quash the defendant's subpoena since there is no purpose and no appropriate purpose in calling a witness simply to invoke in front of the jury. The judge asked if Wendi would invoke her Fifth Amendment right to any questions, and her attorney said yes. The judge says Wendi would testify under the state subpoena and cross-exam would be limited to what the state brings up on direct, and she's not going to be permitted to be called as a witness. Now that we know that she's just going to assert her Fifth Amendment rights, she won't be called as a witness in the defense case at this time. So that, again, was from a prior trial for Katie Magbanawah. So I'll keep you posted. If anything new comes up before trial, we'll start that crash course probably on Monday. So look for that. In the meantime, hope you guys have a good rest of your afternoon, and we will see you soon.